116 clause 2 of the Constitution. In this circumstance, I'm trying to make it complete by providing for a date. Then we go to our clause 2, which is a substantive clause. Now, this clause says Article 202 of the Constitution is amended by deleting the word equitably appearing in clause 1 and substituting, therefore, the word equally. Equally. I would have said by deleting this and replacing. But because there are words, I said in words we substitute, therefore. In this circumstance, the main thing I wanted to demonstrate, one, is that in amending the Constitution, we have to do an amendment bill. In amending an act of parliament, we have to do an amendment bill. There is no shortcut about it. Now, but in amending regulations, we have to do an amendment regulation. Even if we're changing one word. If we're doing a rule, we have to do an amendment rule. So amendments is that paramount. So I want to go to the next example, which I hope will help to relate with what we've covered earlier. The example 2. The second example says you are required to amend the Constitution to provide that all the revenue raised in the country, and I've bolded this, be shared equally between the national and county government. To be a very good idea. Anyway, so if we say you are required to amend the Constitution to provide that all the revenue, the other time we were only amending revenue raised nationally. At this time we say revenue raised in the country. That means we want revenue raised in our several counties to be put together with revenue raised by the national government into the consolidated fund, and then it's divided equally between the national and county government. We are saying, for instance, that now we have revenue raised from 47 counties put into a consolidated fund, revenue raised nationally put in the consolidated fund, then take 50%, give to the counties, 50% leave for the national government. So you see, your requirements, the instructions from your client are different. This one is asking you to do revenue raising in the country. Now, for us to do that amendment, the same article, the same provision of the Constitution is what we have to deal with. This is Article 202, Clause 1 of the Constitution, which says that revenue raised nationally shall be shared equitably among the national and county governments. We have already looked at that provision. So let's try to amend this one to meet the requirements and the instructions of this particular client. We have it up there. I keep on repeating it. It says revenue raised nationally shall be shared equitably among the national and county government. What we are looking for here, are we applying the correct language of amendment? That is what the test we are trying to meet. So again, we have to draft a whole amendment bill. Here I've removed the long title, I've removed the enactment clause, and I removed the title of the Constitutional Kenya Amendment Bill. So I've removed the enactment clause you should have read. I've removed the long title we should have read, an act of parliament to amend, because a bill for an act of parliament to amend the Constitution of Kenya. So I'll come straight to the short title. This bill, it says this act in a bill. Short title we call it act now. So this act may be cited as the Constitution of Kenya Amendment Act 2021 shall come into force on the 1st day of July 2021. I've added the commencement clause. Now, the substantive amendment to meet the requirements of the drafting instructions is that Article 2 of the Constitution is amended in Clause 1. Remember, it's Clause 1. So here I start with Article 2 of the Constitution is amended in Clause 1. Because that's the first clause where the issue is by A. So we have divided it into A. The other side, we didn't have those divisions. A, inserting the word and from counties immediately after the word nationally. So revenue raised nationally. So inserting the word and from counties. So it will be revenue raised nationally and from counties shall be shared. This one reads equitably. So we also in the second amendment reading, Article 202 of the Constitution amended in Clause 1 by deleting. The first amendment is inserting. The second amendment is deleting. By deleting the word equitably, appearing immediately after the word shared, and substituting therefore the word equal. Our new Article 202 clause 1 will therefore read, revenue raised nationally and from counties shall be shared equally among the national and county governments. Remember, we have 48 governments, so an interpretation would be that we have 48, we divide the whole revenue by 48, or we have 48, we divide the total revenue 50-50. Well, that is an interpretation better. But as for the purpose of amendment and clarity of law, what you want to appreciate is that this has required us to have the First Amendment A and the Second Amendment B. So that the First Amendment, you add and from counties. The Second Amendment, you delete equitably. Why do we do that? Why don't we just say by inserting the word and from counties and by deleting the word equitably? No. Because when these questions are put at the second reading of the bill, then the House may adopt the First Amendment and negative or decline to take the Second Amendment. So if each question is put on its own, therefore we cannot cloud all the amendments together. So we put the first requirement and from counties. If it's taken, then that is passed. Then the second one is put as a question equitably. If they want that, if they want to say share it equally, then it's adopted. If they don't want to share it equally and they want to get revenue from national government and county government, but still share it equitably, then they may decline the Second Amendment. That's why we put each amendment must come on its own. So if you have two amendments, then you'll have A, then you'll have B. If you have more, you'll have C and D. In this particular article, you can have so many amendments. Or you can only have one amendment, like we had in the other one, where we were only amending nationally and from counties, but the sharing was still equitable. In this circumstance, we have revenue from national and county government, but the sharing should be equal. And the third example that I have here, and I hope we are on. Is that way you can confirm?
Yes.
Oh, we are on, yes.
Yes.
Okay. So the third amendment is an amendment of a statute, an existing act of parliament. I was saying that we can amend the constitution, we can amend an act of parliament, we can amend a clause in a bill. We can also amend a statutory instrument like a regulation, an order, or a rule, or a guideline. So whichever amendment you want to do is informed by still the language of amendment. In this circumstance, I've picked section 76 of the Marriage Act. Remember, we have the new Marriage Act, which passed in 2015. In that act, section 76 says, this is the marginal note. It says effect of a promise to marry. Now, the provision says, except as provided in this section, a promise by a person to marry another person is not binding. That is the law as it is. That is what the law says. I was saying at common law, or at some goodwill, there was a provision where effect to marry is actually an offense somewhere. No, what you're saying is that for purpose of amendment, suppose we wanted to change this and say it's binding, because this is a social issue. We said amendments are done not because a law is wrong, but because of changes in circumstances. Could be social circumstances, could be. So suppose people are abusing this provision because this is the law. Suppose a member of parliament has a feeling, or somebody, a citizen has a feeling that there are so many promises, for instance, and that they're being abused. You may want to call for an amendment. So suppose the amendment is to make this to be binding. Then again, what I'm emphasizing is that for any amendment, even if it is a word or two words, like in this circumstance, you have to draft an amendment bill. That bill has to have all the provisions of a bill, which I'm sure you've learned in class. And that bill has to undergo all the requirements: public participation, money bill determination. So it is a bill like any other, whether or not is small. Remember, we can also do this through the statute law miscellaneous amendment, which will still require all the journeys of a bill: public participation, to require public participation, to require money bill determination. It will require all those things. So again, in amending this, I've come up with Section 76 of the Marriage Act. In this act referred to as the Principal Act, we always put this if you have other amendments before, so that in your other amendment you just be saying the Principal Act, the principle. You now not say the Marriage Act. You say it's now Section 78 of the Principal Act, Section 80 of the Principal Act, so that you don't need to repeat the word Marriage Act. So we first, in our first amendment, after introducing, doing the short title, the second provision or clause of that bit says that Section 76 of the Marriage Act, whichever act it is, and you bracket and put in this act referred to as the Principal Act. Some people say hereinafter. No, we say in drafting we don't want legalese. So hereinafter we can use in our other legal writing, in demand notes or in other documents, in submissions or in contracts. But in legislative drafting, we try to get away from legalese or lawyerism, and therefore we try to use simple language and then say this act referred to as the Principal Act is amended by deleting the words is not, if you look at up there, and substituting therefore the word shall be. So we're deleting the word is not, and we're substituting therefore the word shall be. It should read therefore, except as provided in this section, a promise by a person to marry another person shall be binding. So what we're trying to say is to get the language of amendment. You note I've used the word deleting because these are words. It's not a section. We are not doing away with the whole of this section. If we're doing away with the whole of Section 76, we would have said Section 76 of the Marriage Act is repealed and replaced by the following new section, and we put a new Section 76 and put it. That would be repealing and replacing because we'll be dealing with a section. But now, because we're doing away with words, we are saying we delete and substitute therefore. So I was just trying to capture the language of amendment here, because here we are deleting and substitute therefore. We are not repealing and replacing. But I say if it's a constitutional article or if it's a whole section, then we repeal the whole section and replace that section. Now, other considerations which I've mentioned in amendment, we have to check if you get instruction. Now, are the amendments substantive or miscellaneous? There are certain times where the instruction you get is such that the amendments that you are required to do are so many. That means the quantity is so large. So in which case you decide, if I had to do all these amendments, then I would rather just repeal the whole bill and bring in a new one. Remember our definition of amendment in Section 2 of the Interpretation of the General Provisions Act, Cap 2 Laws of Kenya, say that amendments include repeal and replace. So you can amend the whole act by removing it, bringing in a new bill. You have repealed. So if the amendment is substantive, then we don't do miscellaneous amendment. We can repeal. Or if the amendments are miscellaneous, the small, then we can decide to take them into an omnibus law. We have the security laws amendment. We take all the laws relating to security and we make the miscellaneous amendment. We can have land laws amendments. We take all the laws relating to different land laws, land statutes, and we amend them. Or penal laws amendment. We amend the penal code. We amend criminal procedure code. We amend others. So we bring. So based on whether it's substantive or miscellaneous, it will inform the nature of amendments that we're going to do. Again, it can be substantive in a way that you're only amending a word, but now that word may be we may bring a big change, like the circumstance we're doing in example of giving in the constitutional amendment. Or better still, you want to remove the board. You want to remove a whole board. And you see substantive just by deleting one word, by saying, or you want to disband the council, council of legal education. It's only a section. By saying that Section 3 of the Council of Legal Education Act is deleted. It appears small, but it brings the effect is substantive. So again, it may be a small amendment in terms of drafting, but it's substantive in terms of effect. So what I'm saying, that is a consideration you need to make before you start your amendment or advise your client. Again, we have consequential amendments. Does it affect other laws? Let me give the example of, again, Kenya School of Law Act. Any amendment generally of Kenya School of Law Act will call for a consequential amendment, perhaps in the Law Society of Kenya Act, or in the Council of Legal Education Act, or perhaps in the Advocates Act. They are related. So we could have an amendment which will call for you to amend other laws. So you need to be you need to be very well, very good knowledge of the statute book, so that you know one amendment can affect another. So it's not just the law you're dealing with. If you have a requirement to amend one land law, get to know it may affect other legislations that are relating to land. So does it affect other laws? That is a consideration. Again, consider the drafting of marginal notes or head notes in an amendment legislation. So drafting of marginal notes and head notes are done in a way that if you're drafting a marginal note, in Kenya we draft marginal notes. Head notes are only used in the constitution. What we see in the Kenya law that we download, that has been converted, but the official drafting style is we use marginal notes on the side, the small ones, smaller fonts. So in an amendment, if you have amended, if you have repealed and replaced Section 3 of the Kenya School of Law Act, we will say in the marginal note, repeal and replacement of, if it's number 2 of 2012, that's what you say, repeal and replacement of Section 2 of number 2 of 2012. You don't mention the act. If it's repeal and replacement of, like we used to have the Land Registration Act, so you say repeal and replacement of Cap 300. Repeal and replacement of Cap 300. Now, if you are only amending a section, then in the marginal note you say amendment of Section 4 of number 2 of 2012. So drafting of marginal notes is very important in amendment. Those are the considerations. Now, what are the effects of amendments? The effects of amendments is that we end up doing away with a bill, with an act, because you repeal the whole of it. Sometimes even a bill, you can also repeal. You can do away with a whole bill, and it dies. It doesn't see the light of day when it's repealed fully. But you can also repeal and replace. That's an effect of amendment. We have rectification. For instance, if Parliament passes a particular law, and this law, in the discussion, in the debate, they had some provisions, but in the publication and perhaps assent, it comes into force. So when that happens, and the effect is minor, it is an error on the record, on the text. Now we do not need to take this law back to Parliament to be amended. The effect of amending it here will be done by the Attorney General, or if in the county governments, it can be done by the governor, by the county attorney, by the county attorney. So the county attorney, through revision of Laws Act, Cap 1, Laws of Kenya, the Attorney General or the county attorney can prepare what we call a rectification order to correct an error in an act of Parliament that has been assented to and requires to be corrected. So you do not take it back to undergo all the amendments. We do that, and then once the rectification order is made pursuant to Cap 1, it is published. Once it's published, it becomes law and becomes the official version. So it does not need to go back to Parliament. Now, the same effect is on, for purposes of statutory instrument. So what a rectification order is what a repeal is, not rectification, what a repeal is to an act of Parliament is what a revocation is to a statutory instrument. So for statutory instrument, like for rules of procedure, like civil procedure rules, court of appeal rules, or any other rule, or if we have regulations, the land regulations, we do not repeal them, we revoke them. So repeal is to acts of Parliament, but revocation is to subsidiary legislation. Then you also have annulment. Now we have situations where the courts can annul certain provisions, declare them void. Now if the court does that, we may not necessarily change the text of the law, but it stands annulled. That's an effect. So courts can also amend if they make certain ruling in judgment that may have an effect on the text of an act, and that means it is annulled. And lastly, we have the corrigenda. So for the corrigenda, the same way we are saying we make a rectification order for an act of Parliament, we can have a corrigenda for a statutory instrument, or a corrigenda for a regulation, we correct an error in a regulation, and we don't need to take it back to the maker. If the CS is given powers to make regulations, we don't need to take it back. And so we correct it by way of a corrigenda. I try to move very fast, and thank you for the issue of amendment. So if you allow, and I'll ask Madam Kumu to comment, if you allow, we can take another 3 or so minutes, and then we go to our next presentation so that we take questions at the very end. Thank you.
Thank you very much, Mr. Dima. That was quite insightful. To give you time to just take a glass of water, maybe we can just take just a few questions so that we give you time to just transit to the next presentation. We can take a round of questions for the next 10 minutes. I think it's only fair we give you some time to catch up. So I will invite a few questions. Please raise up your hand if you have a question, then I call you out. Do you have any questions so far on the issue of amendments? Any question? Okay, so we have Jacqueline. Jacqueline, please unmute your microphone and proceed.
Yes, good morning.
Good morning.
Hello, can you hear me?
Yes, we can hear you.
Yes, I have a question. I have a question with regards to amendment. Let's say, for example, amendment of the Constitution. And for the purpose of exam, now you've been given a scenario where you have to amend the Constitution. And let's say Article 31 of the Constitution on the privacy, and maybe they have given you instruction to amend or to delete some words and insert some words. When you are answering that question, do you have again to go and start by stating that this Constitution shall be cited as the Constitution of Kenya Amendment Act, and then you go ahead and then start amending, answering the question, or you just go straight to the question?
Thank you, Jacqueline. That was short and precise. Do you have another question so that Mr. Dima can pick two? Yes, Trevor? Trevor?
Oh, thank you. Good morning, everybody. So, my question is regarding the money bill. Mr. Dimas just elicited to us that the money bill, you need to know first whether a bill is a money bill or not, and this will depend as to this will determine whether it goes to the National Assembly or to the Senate. So, to what extent is a bill a money bill? Because looking at the Constitution, the money bill excludes Article 218, which is on revenues, and my understanding is that a money bill touches on anything money. So, and again, what is the difference between the money bill and the finance bill? Thank you.
Thank you. We can take one more question, so I will allow Mr. Dima to respond before you can switch to the next presentation. Do you have any other? Okay, I think that's what we have for now. Thank you, Trevor and Jackie. Mr. Dima, I think you have had at least a minute or two to just. Mr. Dima, are we with you?
You can hear me?
Yeah, now I can hear you. Proceed.
Okay. Those are very good questions. Thank you very much, Jacqueline and Trevor. I'll start with Jacqueline's question. For purposes of exam, and I like that particular one. Now, I need to know exactly how this question would have been framed. Say, if we just had it, I think we can look at that later. Because I always want, if I got the question exactly the way it's required. Remember, if they want you to change those provisions, then it will be so difficult if you do not go to the bill, because you're in a drafting class. So it will be very simple. That's why in my example, I gave only two provisions. You can hear me?
Yes, we can hear you, Mr. Dima. We can hear you.
Yes. So remember, I gave two provisions. You want to amend Article 31 on privacy, for instance. Let's use that as an example. That we tied with that article and we want to do away with it. So for our language, of drafting, we call it repeal. So we have to amend that constitution, the Article 31 of the Constitution. That's the instruction you've been given. We say the first thing, you have to draft a constitutional amendment bill. That is the first one. So there's no way you can, because in drafting, in crafting it, you cannot do that other than by way of a bill. So I'm assuming I'm in a class, I'm in an exam situation. It may appear simple for me, but also simple for us lawyers. All that you need to do is to do one line Constitution Amendment Bill 2021, you know, and then you have to do the other line which says a bill for an act of parliament to amend the Constitution of Kenya. Then you go to your short title and say this act may be cited as the Constitutional Amendment Act 2021. Ordinarily, what I forgot to tell you again, the first amendment of the Constitution that is not numbered. If we have a second amendment which is published, we say number 2 in bracket, Constitutional Amendment bracket 2. If you have a third one, Constitutional Amendment bracket 3. If it is a 10th one, Constitutional Amendment bracket 10. So, but that is only at publication. So if you are drafting, you keep on increasing the attempt of amendment. Remember again that since 2013, we always have every year so many attempts to amend the Constitution. None of them has gone through. Perhaps we may have the first one this year. So what I'm trying to say is that provide for those 4 clear provisions. Title of the Constitution, the Constitutional Amendment Bill 2021, and your word amendment should be in brackets. Then an act in capital, an act of parliament to amend the Constitution of Kenya. Then you go to your clause 1 of that bill, which is the short title. This act may be cited as the Constitutional Amendment of Kenya Act 2021. Then you go to your crux. Then in 2 you'll say you say the Constitution of Kenya is amended by repealing Article 31. Full stop. So you see, it takes you 4 lines in an exam. In my view, it only takes you 4 lines to write that. You already drafted a bill. Remember, you're in a drafting class, so they're testing other things. And they're testing your knowledge. That, are you aware that to amend the Constitution, you need a bill? So what they're testing could not only be this, but they're testing the skill in that. So my advice would be, because it will only take you 4 lines, just draft the title, the bill, draft the long title, an act of parliament to amend the Constitution of Kenya, draft the short title, the Constitution of Kenya. This act shall be cited as the Constitution of Kenya Amendment Bill Amendment Act 2021, and go to your crux in the second one and say the Constitution of Kenya is amended by repealing Article 31. That's an example. But if you are repealing a clause in that article, say what you have to do away with is clause 2, not the whole of Article 31. Then you start with the word Article 31 of the Constitution of Kenya is amended by deleting now or repealing clause 2. Because clause 1 is okay, clause 3 is okay, clause 4 is okay. What you don't want is clause 2. So the language is based on what you want to do. If you want to go away with the whole of Article 31, then start with the Constitution of Kenya is amended by repealing Article 31. But if you want to delete a word in that provision, or in that article you want to go away with clause 4, then start with Article 31 of the Constitution of Kenya is amended by deleting or repealing clause 4. I hope my answer there was clear. What I'm saying is that it's imperative and important that you draft a bill, which in my view will take you some 2 or 3 minutes, just providing those provisions and then going to your answer. The other one, what Trevor has asked, is just a bit technical quite. The issue of money bill is controversial. We've had cases both in Parliament where the Senate has taken the National Assembly to court. The National Assembly has taken the Senate to court on matters bills. One of them is whether or not there were money bills, or whether there were bills concerning counties. So aspects of money bills are contained in Article 114 of the Constitution, and it tells you what a money bill is. It breaks down. Now, to make that easier, what has always happened is there is under PFM, Public Finance Management Act, there is established an office known as the Parliamentary Budget Office. and its mandates, functions are stipulated. One of the things they do is to analyze. It has a lot of fiscal analysts, is to analyze every bill and quantify the money effects of that bill in the national budget. How will it affect the national budget? So, if, for instance, it's going to have a board, this board will have members who will earn salaries. It will have a fund, all that. So, there are so many things that are used to determine whether or not a money bill or a bill is a money bill. And that is also stipulated in Article 115 of the Constitution. If you go there, you'll get that. But there's an office use that. So you need to know whether it's a money bill or not. Now, in Parliament, it's so easy. That will not be asked as a question, but it only determines where or not it starts. We are saying a money bill can start in the National Assembly, then it goes to the Senate. But it cannot start in the Senate, because that's what this Constitution provides. So it only determines where the bill originates, only that. And two, that is done in two ways. One, it is subjected to the Parliamentary Budget Office to determine whether or not it's a money bill. That's not, drafters can do that, but you don't want to load yourself with that. Give them their fiscal analysts, they get the determination, then they give you, so you see how to proceed. Again, if it is a money bill, then it will always go to the Budget and Appropriations Committee. Again, Article 114, Clause 2 of the Constitution says, if it is a money bill, then it will only proceed in the manner determined by a relevant committee of Parliament. Remember, that is the Constitution. Again, if it's not a money bill, then it does not go to that Budget and Appropriation Committee. It goes directly to the Departmental Committee. If it's a matter on education, then taken to the Education Committee to determine. If it is a matter on say, finance, taken to the Finance Committee. It is a matter of, so if it's not a money bill, then it skips 2 stages. It will not go to the Budget Committee. And remember, the Budget Committee will determine whether or not a bill should move or a bill should die. So that's the effect of a money bill. But for you as a drafter, at your point, you just proceed to draft and let the determination be done by that House of Parliament, because it's a constitutional requirement, and also in Standing Order 114.3b of the National Assembly Standing Orders. It also provides the same with what is provided in the Constitution in terms of money bill determination. I hope Trevor got directions on that, but I'll ask Madam Kumu again because of time. If those are questions, we can always engage you later on these matters if you care.
And I think you can proceed to part 2 of your presentation, Mr. Dima. I ask students to post your questions in the chat. We will have a final plenary session in the next hour or so. So, Mr. Dima, you can proceed and do your second part.
Okay. Thank you very much. I hope you can see me. You can see the slides.
No.
Not yet.
Not yet?
Not yet.
Yes.
Okay. Just give me a minute.
All right. As Mr. Dima prepares to project his slides, I invite Mr. Munyidhia. Mr. Munyidhia, maybe you can say a few things to your students.
Thank you. Yes, thank you very much. Even as we join the second session, I want to say thank you to Wilson and those of us joining us. I think this is a very critical time for purposes of legislative drafting to try and engage the speaker in understanding the technical aspects of how to engage in terms of questions that come during legislative drafting. But I would like to remind us that it's good to recapture even what we have covered this time. I hope those of your classmates who may have missed, you tell them to join the afternoon class. You can send questions on the chat and then we'll be able to review them. Thank you.
Thank you, Mr. Munyidhia. Mr. Dima, are we now ready?
Yeah, yes. 1 minute.
Okay.
Penalty provisions.
Hello? Hey. Hello? Wana nini?
Can you see the slides?
Yes.
I can see from my side.
Okay. Sorry about being a bit challenges in technology. ICT. So our next presentation is on penalty provisions in legislative drafting. And again, we are aware that if we draft any legislation, there is no way we can enforce them. Implementation is different, but enforcement of certain provisions of a law cannot be done if there is no mechanism of enforcement. And that enforcement can only be done by way of providing for penalty provision. I'm giving an example here, a penalty provision. For instance, a person who contravenes any provision of this act for which no penalty is provided commits an offense and shall be liable upon conviction to a fine not exceeding 50,000 shillings or to imprisonment for a term not exceeding 3 months or both. This simple provision that I've tried to put here carries a lot of weight in terms of penalty. We are saying that, you see, it does not have the word is guilty of an offense. That was sort of a kite drafting. We could say guilty of an offense because we presume that the guilt is only determined by court. It cannot be determined at this level of drafting. So we say if you commit an offense and if you are convicted, then you're liable. We provide for a fine, we provide for a prison term, and we may provide for both. Certain times you have situations where provisions only have prison terms and no options of a fine, or a fine without option of a prison term. What happens if you can't pay the fine? So as we move on, we'll understand this. So I'm just saying that we use the correct terminology: commits an offense, shall be liable upon conviction of a fine. And then again, in Kenya, in very few acts, in POCAMLA, Process of Crime and Anti-Money Laundering Act, and again I've seen that in one provision in the Traffic Act, where they have provided for a minimum fine. They've provided minimum fine, but it's not encouraged because we leave that for the discretion of the court. We give a maximum. Now, in principles of drafting penal provisions, it's important that the offense is introduced by a description of conduct under prohibition and the declaration of this conduct as an offense. So we cannot have an offense if it's not properly provided for. So without express declaration of a conduct as an offense, there is no offense. So we cannot have an implied criminalization. So in drafting, it's important that we clearly provide for the conduct, we provide for the sanction, we proceed to prohibit that sanction, and we provide for optional violation. And then if you violate it, then we tell you what will happen by way of a sentence, prison term, or a penalty. We always say that certain times, maybe to give the best example, is that we always say that in certain aspects of law, for instance, the Deuteronomic laws, they do not give you an option. They say thou shalt not do this, and that's it. So you are not given, and you're not told what happens to you if you do it. So for purposes of drafting, it needs to have all the clear elements. Now, the objective element is the doing part of that conduct. The action you've done, the omission you failed to do, or we have specific factual elements that must take place for the conduct to lead to the offense. I'm sure you've done that. We've done that in our criminal procedure classes. Again, there's a subjective level, and which is the thinking part of that conduct. What is required? How is fault established? In drafting legislation, we must clearly provide for that. So we have classes of offenses, which again, in this one I'll move very fast because I'm sure we have done this in our criminal procedure classes and also in our criminal law classes. And so it's just the drafting of it that is most important. Now, in drafting, we must provide for the mental element. So, of course, we know the mens rea. It's a prerequisite for prosecution. So we must say a person who knowingly does this. You may say a person who does this, but we must provide for, did he do it knowingly? Did he do it intentionally? If he's driving, a person who recklessly drives. So we must provide at the drafting point the element of mens rea to allow the court or whichever institution will be analyzing the charge to visit the element of mens rea. Then we have another class where proof of mens rea is not a prerequisite for prosecution. We have offenses of strict liability where total absence of fault is not a defense. So I don't want to delve so much into this because I want to do the drafting part of it only, and because this we have done, as I'm saying. Now, what are the other considerations? Now, when you're drafting offenses to bodies corporate, generally we only include fines. If a body fails to do this, then we can fine them because an institution or a body can pay a fine. We can also deny them their licenses, or if we're to renew license, or sometimes we can force them to restore. If you look at EMCA, the Environmental Management and Coordination Act, it has a lot of provisions on restoration offenses and also fines. So here, we're dealing with bodies corporate. Recently, though, we've had situations where, and this is departing from the general principles, where you have bodies corporate having the directors or institutions having their main management being subjected to criminal liabilities, which is not very right unless somebody is charged as an individual. But we are saying that drafting offenses to bodies corporate in any law, please provide for fines or other ways of penalties like licensing, renewal, denial, or forcing them to restore over and above the fines. Again, sometimes we include defenses. I'll demonstrate that in our another slide. I've given an example, Sexual Offences Act. For instance, when you're drafting, you must remember to include a defense because you're thinking for the circumstance where that particular provision will be actualized ordinarily in a court of law. So for Sexual Offences Act and defilement cases, for instance, we always say it shall be a defense where, and I'll show that later, shall be a defense where the accused had reason to believe that the victim, in this case, or the complainant, was over the age of 18. Because if it's over the age of 18, it could turn to rape, there could be elements of consent, so it will not be a defilement. So it is a defense in a defilement case. As an example, when you are drafting that is just an example. Ensure you can sometimes draft a defense provision. We have in several acts where we have defenses. Shall be a defense if this and that happens. Now, again, there are requirements for consent of the DPP before prosecution. Remember, currently, the DPP is constitutionally, the office which prosecutes publicly. Formerly, it was Attorney General. So, in several acts, we still find consent of the AG, but currently, with the new constitution, it's consent of the DPP. So, again, requirements for this consent of the DPP is necessary in certain offenses. If you look at the Public Order Act, it says offenses, no prosecution under this section shall commence without the written consent of the Director of Public Prosecution. So certain offenses, you cannot commence them without that requirement. So as you draft your legislation, look at the weight, and then you may want to give a defense, you may want to give the consent of the DPP. Again, in another slide down here, I'll give you an example of the Biosafety Act, which says no prosecution under the whole act may be commenced without the written consent of the Director of Public Prosecution. Again, sometimes we want to decide and include the level of jurisdiction of criminal court in a statute. And this is always done at section 2, or whichever section has the definition or interpretation. So if it may be important that you say court means the High Court, or court means a Chief Magistrate's Court. So based on the criminal nature and where it will be sentenced. For instance, we know that murder cases cannot be tried in other courts. So, or let me just say generally capital offenses. So you may, and you are the drafter, as you're drafting that provision, you may want to provide for the jurisdiction of the criminal court. What I've mentioned, the minimum and maximum sentences, I've seen in certain circumstances nowadays, we provide for minimum, not less than and not exceeding. But generally, we want to just draft a maximum sentence or maximum prison term. Let the minimum be up to 100 shillings or whatever. But because in Kenya, we don't have sentencing policy. So it's the drafter that will inform what will happen. Ordinarily, as I've always said, the parliament, the members of parliament or county assemblies will concentrate on the substantive part of the bill, and they'll always leave the penalty. So for you, the drafter is important that you weigh out and put a maximum sentence, and also the weight. Don't make it 100,000 if you think 50,000 would be sufficient for that offense, or 6 months in prison. You may also include administrative penalties. For instance, if it is in an administration institution, you can say the first will be stepping aside, the second will be suspension. We also have circumstances where we say this thing or whatever offense or nature of offense may have to be tried somewhere first before it goes to court, like a tribunal or something like that. So we also have penalties provisions in subsidiary legislation, and in subsidiary legislation, this is controlled in Cap 2 and also in the Statutory Instrument Act. And subsidiary legislation, Cap 2 says if any subsidiary legislation provides for a penalty, it should not exceed 3 months or 20,000 shillings. The Statutory Instrument Act caps it at 6 months and 20,000 shillings. So you cannot provide in a regulation anything beyond that unless the act under which that regulation is made allows for that term. So ordinarily, sometimes we go beyond, but you cannot go beyond the penalties that are stated in the act. So you may be called upon to draft regulations for a particular institution or rules or orders. So be sure that in your drafting of penalties subsidiary legislation, you go by the requirements of both Cap 2 and the Statutory Instrument Act number 23 of 2013. Again, you can use pictorials and symbols. This is very common. The Tobacco Act, for instance, the Alcoholic Drinks and Control Act, the Traffic Act, and you see a pictorial. It will say that penalties of, you've seen in certain establishments where they'll say that smoking of cigarette will attract a fine of 50,000. Well, that's the maximum fine. It's not just a pick that. They'll pick that from the law. If you go to the schedule to that act, you'll find they've drawn a figure and they've put cigarette and cross, just the same way they use no smoking. The same way we have in traffic offenses, no waiting, no parking, no waiting. So a person shall not park in this and that place, and then they put a symbol. So you can use pictorials and symbols in the schedule in certain provisions that deal with matters penalty. Again, other general issues that are important for us in penal provisions, we may have a general penal statute for specific offenses in the various statutes. For instance, the penal code. Our penal code amasses several offenses and pulls them together, yet they address different sectoral laws. So we may have that. And we may also have, whatever it is, it must be consistent with the Constitution and the penal statute and the related statutes. For instance, if we cannot create, I'm giving that example there, we cannot outlaw abortion in a particular statute. Some members or drafters could be very emotive and you want to outlaw, say, abortion irrespective of the circumstances. Yet the Constitution provides for where, for instance, an abortion may be conducted. We have issues of bigamy. So there are things which, if you're providing for as penalties, you must be consistent with the Constitution, the penal statute and related statutes. we cannot, for instance, our constitution still allows for, say, death penalty. So we cannot go to a statute and completely outlaw it. It must be consistent with the constitution. Or if the constitution doesn't allow it, you cannot provide for it in a statute. So in drafting penal provisions, we must be cautious of that. Again, what you intend to prohibit must be very clearly contained in the act or the omission. I've mentioned that it must be very clear. Then again, clearly provide for the sanction. What sanction do you want? Is it a discharge, like Section 87 of the Criminal Procedure Code? Is it a fine that you want? Do you want somebody to be committed to community service? Is it a prison term? Do you have supplementary sanctions like what I've said, suspension? Do you have sanctions which are imposed under aggravating circumstances? For instance, a repeat of this. If you're a first offender, you may provide that anybody who commits a traffic offense a second and a third time in subsequent offenses may be denied his driver's license. So you have to provide for sanction imposed under aggravating circumstances, which somebody is a repeat offender, for instance. Then you must provide for the consequences of breach. We're saying this could be a prison term, this could be so much fine, because that's when we'll be enforcing. Then penalty for non-compliance also contained in sentencing policy. But in Kenya, we don't have a sentencing policy as it is. The judiciary tried having one, but that was only making uniform their sentencing, so that a judge in Mandera or a magistrate in Mandera would give the same sentence for a similar offense with the one in Malindi, so that they don't have to be so much varied, much as it's within that window. Then it's important to cognizant of territoriality in jurisdiction. This is very clear in our circumstance in Kenya, where we have now we have several counties. So an offense in one county may not be an offense in another county. So we need to be cognizant. If you're drafting for counties, check your territory, your jurisdiction, which may be an offense somewhere and not an offense in another place. We've had jurisdictions where, just giving an example, our sisters and brothers who are Muslims, for instance, or the ladies especially, in Saudi Arabia, if you have a county in Kenya, for instance, which is a particular religion, do not allow particular dressing, then you must be cognizant. You cannot use that neutrally in all the jurisdictions. So that is important. Now, I'm giving an example of a defense in a penalty provision. I've already mentioned this. I'm saying it shall be a defense where an accused person had reason to believe that the complainant was aged 18 years or above. Most of us who will be defense lawyers practicing criminal law, this will be a very clear defense, and it's important because it may be demonstrated that the accused had that reason because of maybe the body of the complainant, or the presentation or that kind of thing. So it's important to think of that in law at the point of drafting. Again, I was giving this example where we have in the Biosafety Act or in the Public Order Act and several other acts that no proceedings for an offense under this act, or sometimes an offense under this section, shall be instituted without a prior written consent of the Attorney General. And I said I was going to be very short in this one because it touches only on how you draft criminal offenses and how not to draft criminal or penalty provisions in various acts, and whether or not we can lump them up in several acts, or we can bring them under specific statutes or bills. Thank you.
Thank you. Thank you very much, Mr. Lima. That was quite insightful, and perhaps as we gear towards the end of the year, the academic year, that was very, very useful for the students, and practical examples of how to relate and how to, if you are given a question like that one in the by exam, how to go around it. Great. I'm saying it's 11 sharp. I will invite a few questions. Then I hand over to Mr. Munyithia just to do the final bit. Now, I can see a question from John Ogeno. Please proceed.
Yes, thank you. I have a question with regards to the effect of the immunity clause included in a statute. So when you have an immunity clause, I believe you have to include the term in acts done in good faith. So what happens when that act is not there, when that statement is not there, acts done in good faith, and what is the effect of the immunity clause with regards to the penalty made? Thank you.
Thank you, John. Do we have any other question? So that Mr. Dima can take maybe a couple and respond to them. I'm not seeing any question in the chat. Anifa? Then we have Dindi. Anifa?
To give the slides.
Yes. Anifa, that will be availed by COB. I will forward the same to all the class reps of A, B, and C respectively. Okay, Didi, you have a question?
Morning, and thanks for the presentation. My question is on penalty provisions in the amendments. Does it have the effect of amending the penal code, or what is the effect of the amendments on the penal code?
Thank you, Dindi. Do you have a last question so that Mr. Dima can respond to all? Any last question? Just again looking at the chat so that we don't leave out anyone. See a question by Achia. Okay, I think Mr. Dima, you can respond to that. Mr. Dima, are you?
Okay, you can hear me?
Yeah, you can respond to that, then do your very final part, which I know will just take 5 minutes or so. Then we close it.
Now, I really didn't quite get Joe's question, but I can imagine what he asked, whether or not we should include issues like in good faith, if something is done in good faith, in terms of a defense. So that is also a common defense line, which if we introduce in our legislation, for instance, in companies, in institutions, it's a common thing which we say that no member of staff or member of the board shall be held liable for having conducted for any offense or any conduct if the offense was done in good faith. So that is also one which is very common, especially if you're creating a corporate body in an act, then it's good to cushion. It's good to cushion so that members of staff or members of the board are not held liable for issues or offenses which should be a liability of the whole institution. If I got him right. So that one we always put, if it's done in good faith, then you're not liable. I hope that's what he was asking. Then for Ndindi, whether or not the penalty provisions in the amendment in the penal code have effects in the penal code. Yes, they do. If you're called upon to amend a provision in the penal code, then it will have an effect in the penal code. Or if you're called upon to amend another act of parliament or provide for amend provisions in that particular act so that you provide for new penal provisions, maybe to enhance them. I did, for instance, some time back, enhancement of the offences in the Traffic Act. It was felt because we don't have a penalty provision. Some acts were done during colonial times or sometimes even so many years back, and the offence is 500 shillings. So if you leave it at 500, then people will have repeating. So you amend that provision to enhance. Now, what happens is that it will not have conflict with the penal code. It will depend on the charge sheet. Because if you're charged under the penal code, then that's what the code goes with. If you're charged under whichever act, traffic offense, that's what the code will go with. So the amendments have an effect, yes, but they do not at any time conflict with the penal code because it depends on what you'll be charged with. Remember, this is enforcement and this can only be done through a court of law. Thank you.
Mr. Dima, we can give you 5 more minutes to just wind up.
Yes, I'll just wind up. I was saying if you do, the third thing that we needed to talk about was the expression of time, but this calls for several provisions in the Constitution, in several acts. So I just want to give an overview that in expressing time in a legislation when you're drafting it, it's very important to know whether you want to give the end time. I can see, I cannot, we have the PowerPoint?
Yes, we do.
Okay, then I'll just go over. You see, it's asking that you have to enable or provide for certain consequences to arise at a particular point in time or during a period of time, certain at each end. Or if not, then during where we have both the beginning and the end, but it's not certain. The examples are there. The one I've always given down there where they specified time. Statute of General Application falls in England, 12th of August. We are saying here, anything which was coming in force on 13th of August does not apply to Kenya. So you see, they point at time at a specific time. Again, in our constitution, we talk about when for instance, the declaration of the president-elect, when he's being sworn in, it says first Tuesday. It does not matter. We have specified that date, and we also say 14 days, or we say 7 days. So, again, in this circumstance, this is a long one, but you find it defines when one can become a citizen, and it gives a particular date. If something happened, a consequence was 11th December, your father or your parents or citizens at that date, you qualify to be a citizen. So, and remember, this is the Kenya Citizens Act and the Constitution. So, time matters. You have to be very specific. Statutory instrument say you have to bring in within 7 sitting days. So if you say 7 days without sitting, it means a different thing. 7 sitting days means a different thing. So I'm just saying that for time, providing for time, if the lawyers here will go through the slides, you'll understand more on how time is provided for. In expressing time, we prefer using the word not exceeding, for instance, instead of saying at least. Or we give within so many days. I've also said in the Civil Procedure Act, you see it says 3 clear days. Why do we say clear? Well, this is if the word has been used somewhere else in the Act, then we have to give 3 clear days. That is still an aspect of time. So I want just to make that particular short, because time is so heavy in the Constitution from Article 259, the Civil Procedure Act, several acts of Parliament deal with time. So when you're drafting, be very clear with the time element and use the correct language or expressions. Thank you very much.
Thank you so much once again, Mr. Wilson Dima. Thank you for making time. May I now hand over to Mr. Justice Munyibia just to close the session for us. Justice?
Yeah, thank you. Thank you very much, Dima, for that time. You've taken time off to take the students of Kenya School of Law through this program. Perhaps before I could just give my remarks, may I invite maybe a class representative from class A or B to say something on behalf of the students? Then I'll close. Is Gloria there or Jeru, one of you? Just to say something on behalf of the students? Any of the class reps present?
Yes, sir. I'm present.
Yes, put on your mic and say something then.
Yes, sir. I want to start by sincerely thanking our teachers for the preparation and the arrangements you made for us to enable the guest lecturer to attend to us. Indeed, we say thank you for the love you have demonstrated to us this morning. To our guest lecturer, we say that may God bless him for the time he has set aside and the nugget of wisdom he has given us this morning. Indeed, we shall keep to recall and recollect the sweet memories in the future of what he has spent with us for the short time. And actually, we cannot fail to thank the ICT for the logistics and that they have made to enable us attend this class. Indeed, be blessed more than words can express this morning. Thank you, sir.
All right. Thank you very much. And on behalf of the department, I want to thank you so much, students, for participating and joining in large numbers. I'm aware some of you are following us through the YouTube, but we could say that out of this discussion, you can confidently address any questions on legislative drafting if it comes. I'm sure you are aware now that you know how to express time, you know how to amend a constitution, you know how to follow the set rules in putting penal provisions. Given what is going on in the country, I think you have also become better citizens to equip the Kenyans to understand what is going on with the BBI process in this country, that discussion. Time is with us. I understand you're having another guest speaker coming in the next minutes. But this afternoon, again, for those who do not make it, we are going to have Dima taking us through the same process between 2:30 and 4:30. Of course, this was recorded, and you'll get it on the live stream, what was recorded by the ICT. Thank you very much, and hope to see you next week for Class A. For our next discussion in class. In the meantime, please look at the past papers and see how best you can attempt the questions there to help you practically understand legal writing and legislative. Thank you very much. God bless you. Class is over.
Thank you. Thank you, Mr. Muniria.
Thank you.
Stop recording. So here we have to